Let Gareth press all the buttons.
Good evening, and a very happy Monday to everybody. Thanks very much for taking time out of your Monday evening to come and join the three of us while we talk about self-employment and the rights and wrongs of the law around it, and then also some of the recent changes that are coming if you're an employer or an employee, which I think are really relevant. So as ever with these sessions, we record it, and I'm about to press record now if I can remember where the button is. There it is. So if you don't want to, you're not comfortable with that, I'm afraid, sorry, time to go. And the idea being that we can share the recording with those of us who can't make it this evening. So if you've got any questions throughout the session, please just pop them in the chat and we'll do our best to answer them as we go. And I'm going to say this again in a minute, but we can't offer legal advice nor tax advice because we are neither lawyers nor tax advisors. Speaking for myself, I'm absolutely tickled pink about that. For those of you who don't know me, my name is Gareth Penn. I am the Registrar of the Hairdressing Council, and I'm also the Managing Director of the Good Salon Guide. And I spend a lot of my time lobbying government for a better support, better recognition, greater professionalism for our amazing sector. And I'm delighted that both Sheila Abrahams from the Freelance Hairdressers and Colette Osborne from Salon Owners United are co-hosting this evening's webinar. So Colette, over to you for a quick intro. I'm sure everybody knows Colette.
Yeah, but I'll make it quick because everybody knows I talk too much. So good evening, everybody. I'm delighted to see you all here. Colette Osborne, Salon Owners United, previous life, an accountant and hairdresser, retrained to be a hairdresser, but obviously I have extensive experience here and I'm great to see my colleagues on here as well. So nice to see you all. Hello, Mark.
Thank you, Colette, very much. And Sheila, you need a little introduction. Are you a dame yet, or just still?
No, just the MBE for the time being.
Just the MBE. Okay. So.
Okay, thanks everybody again, for putting time in this evening. I am Sheila Abrahams from Freelance Hairdressers Association, and I'm here because I represent the freelance sector, the self-employed, and very passionate about what we're speaking about this evening, because I know there's a lot of confusion with self-employed and how it should be done correctly, and I know there's a lot of people that don't understand. It is difficult to understand. Hopefully we've got some slides. We've got a lovely presentation that Gareth has organised for us, which should sort it out in your mind for you. So over to Gareth, because I know we've got a lot to get through.
Thanks, Sheila. And now I'm going to try and do the whizzy technical bit now, and share my screen. So give us 2 seconds, and I'll do that now. So I should be able to do that.
While Gareth's doing that, please don't be afraid anybody to ask questions, because obviously, it's really important that we get your feedback and any questions that you have. And no question is the wrong question and no question's a dumb question. So please feel free to ask them.
Hang on, I'm struggling a little bit because I'm not getting, you can see the next slide as well, which means people are going to be thinking about what's coming next rather than about what's coming now. So two secs.
So if you just do slideshow, Gareth, that should help you.
There we go. That should now. There we go.
Yay!
Hooray! Excellent stuff. Right. Brilliant. So, as we've said, the three organisations have come together with this: the Hairdressing Council, Freelance Hairdressers Association, and Salon Owners United. And really pleased to share.
You've muted yourself, Gareth.
Gareth's clearly not as technical as we all think, just so you all know.
There we go. Is that better?
There we go.
You're back. Yes.
Okay, there we go. I'll start again. these are the three of us. Really, really pleased to be sharing a platform with the Hairdressing Council, Freelance Hairdressers and Salon Owners United. And these are the things that we're going to aim to cover this evening. So if you're thinking of going self-employed or being told you are, I imagine you're wondering what's next. So the pros, the cons, and the issues around going self-employed. Again, whether that's a choice made by you or you're being made self-employed. So we're not going to look into whether you earn more money self-employed or employed, or whether one or the other is a better choice. Both are absolutely legitimate, wonderful ways of earning a living, but both can be done illegally, and that's not okay. So what we're looking at here is making sure that if you are going self-employed, that actually you're aware of all the detail around it, and you can make a decision as to whether that is the right employment model for you. And then lastly, we will cover the changes that are coming on April the 6th, which is in a month. And these are the changes brought in by the Employment Rights Act. And if you're an employer, these are important and you need to take action from the 6th of April.
You've muted yourself again, Gareth. Don't press your space bar, press your arrow.
Yeah, you see, you'd think this is like back to lockdown, where it's the first time we've ever used technology. So we don't offer legal and tax advice. If you're in doubt, speak to a lawyer, tax specialist. I think there's two things I would add, and this is particularly Colette's. I hear Colette say this a lot, which is that you have to comply with both employment law and tax law. You can't just comply with one. And a lot of the problems that I believe we're having are around advisors and coaches, some of whom are very good, a lot of whom, how do I describe them, Colette? Snake oil charmers?
Snake charmers. And just coming back to what you just said, Gav, just for people so they understand what we mean by that. So there's no current synergy between employment law and tax law, and that's what the Employment Rights Bill is all about, to actually bring the two together. And Gareth's quite right, because you see a lot of people, and I saw a few today that said that they're switching to a rent-a-chair salon, self-employed, whichever you want to call it. And, you know, that somebody had said they could do it, and I've seen it online. And then we've got people who've actually made the transition, actually teaching people how to do it. You know, and the key thing is here, with regards to employment law and tax law, you can actually be compliant with employment law, but then when HMRC come in, you're not compliant with tax law. I know which one I'd rather be on the side of. So I think it's really important to understand that this is not, and also just to reiterate what Gareth just said, both are legitimate choices if done correctly. This is not in any way, shape or form, you know, having kind of, shall we say, a pop at one or the other. This is about giving people the right advice so they can do it correctly. Gareth mentioned about legal and tax specialists. If anybody's struggling with getting hold of one who understands our sector, then don't be afraid to direct message me or go onto SOU, contact us, and we can certainly signpost you to somebody who understands our sector completely.
Yeah, I think that's really good, Colette, because actually, you know, tax and employment law is not just generic, it is specific to our sector, and it's important that you do work with somebody who understands our sector. Okay, let's dive into, if I don't mute myself again. Oh, I didn't this time, that's amazing. Indicators that you are truly self-employed. So, and Colette, Sheila, do jump in here on any of these. But first off, so what we're looking at here is what are the things that would be used to measure whether from an employment law or a tax law point of view, you are considered self-employed. And there's a long list to pick from. We've selected here the ones which we believe are most relevant to our sector, because this isn't just an issue in our sector, it's a massive issue in construction, for example. It's a growing issue in hospitality. All of these sectors where employment, people is a high percentage of the cost. So you're truly self-employed when you set your own hours. Choose when you work, and you can refuse appointments. Yeah, go on, Colette.
Sorry, Gareth, just to jump in there. I think something's really important here. Before we go through these details, there will be a couple of things. So you might have these written into contracts. Okay, all the things that we're going to discuss shortly, you might have them written into contracts, but if that's what's not happening in real life, as in the reality, then because what happens is both employment law, and especially with the changes with tribunals and everything, and tax law, they will test the characteristics of the relationship, not what's written. So it's really important that what is written is actually replicated how you operate. And on the setting own hours, for instance, to give you an example, just because the salon says they open between 10 and 6 and they open certain days a week, that could actually say that you're actually operating within the salon's regime. So it's really important to be able to distinguish the two.
That's right. You choose when you come to work. So you don't have to be there if you're self-employed when the doors open, because you might not have any clients for a couple of hours. So then it's for you to decide when you come into work.
And you should have a set of keys really to let yourself in like your landlord would. And I think if you consider this, that would your landlord come in and tell you to do these things, that's how you should be viewing it if you're operating that model.
That's a really good analogy, Colette. If you think about when you're renting a chair from a salon, you are a tenant of that premises, just like you can be the tenant of a house or of the shop itself. One of the other indicators is you control your prices and decide what you charge clients. That's fairly self-explanatory, I think. You provide your own tools, equipments, products. So you can see here, actually, it's quite difficult sometimes to be self-employed, truly self-employed.
If I can explain where this comes from, Gareth, because I think it's really important. When we talk about tools and equipment and products, this is all about, would you have to have bought those products to do your job anyway? And if you do, then you should be purchasing them yourself. The reason for that is because it's all about who actually holds the financial risk of the business, because you should be able to suffer a profit as well as a loss. Okay, so or make a profit as well as suffer a loss. And if you're actually not buying those products up front, so you're not buying them till after the service, or and I'm not talking about credit terms here, I'm talking about the salon providing these things for you. Everything there points towards an employment relationship. So it's really important there to understand the distinctions about providing your own products and goods and maintaining your own equipment.
Okay, thank you. And so, Colette, out of interest, just that you got those 4. If you passed 3 of those, but you didn't buy your own products, where does that? Because I'm sure that's the case for lots of people.
Well, to be honest, Gareth, this is the difficulty, because there's something like there's 105 sample testing verifications. So for instance, if I walked into a salon tomorrow, and I worked in compliance years ago, but on the other side, not HMRC side, I worked on the side protecting businesses. So for instance, you could actually, it's not about whether you fail or pass any amount. There are fundamental ones that if you pass or fail, it will stand or fall. What that means is certain things that we'll go through in a second, and I'll tell you which ones are fundamental. So it's not about whether you pass or fail on one, it's about how they determine your relationship, and it very much depends on the investigator or officer coming in. Okay, and what they do is they look at something called, I'm not going into too much detail, but they look at the ready mix concrete test. What that means is they look at previous case law. So they look at the rules, then they look at the latest tribunals or cases that have gone through our sector. So we could use Gorman versus Terence Paul as an example. So the person there had the products, she bought them from the salon, they bought them up front. She worked within the salon hours. They took a percentage of her income. She worked at only one salon for a period of time. So they determined her as an employee. And the difficult thing here, and I think just to come back to that, what's really important, it's down to the actual salon owner to determine the person's worker status, okay, not the worker themselves. So if you're renting a chair in a salon or in self-employed in a salon, or if you're the salon owner, it's the salon owner who's got to determine your status. That all changed on April the 6th, 2020. Yeah, so
Okay.
sorry, bare financial risk. Sorry, Gareth.
No, that's okay. I mean, so you know what that tells. I think what you're saying there, isn't it, is that actually every situation is slightly different.
You're unique, Gareth. They'll all be
Every
treated on their
situation
merit,
is judged on its merits.
which is why people find it confusing, because they're like, well, where's the rules? And as I
Yeah,
said, the rules will be
that's it.
determined for each person. They may determine one person self-employed in your salon, another person employed. It depends on that particular relationship. So you'd have to go for every single one.
Okay, thank you. That's really helpful. So you have financial risk, as in, you know, in the most basic level, you've got no clients, you're not paid,
And you've bought the product, so you've suffered a loss.
and you bought products because you suffered a loss. Exactly.
This is the fundamental one. This is
Yeah.
absolutely Achilles heel for any employment lawyer, barrister, or anybody coming in to look at you. I could say, Gareth, so you work with Sheila. So Gareth, when did you last substitute? When did you last send a substitute in to do your work?
Well, I mean, I do like Sheila, but you know, it's me. I've got to be in there. You know, she won't let anybody else come in my place.
Then you're employed. What this means is, in real terms, is that Gareth could decide to rent chairs in 5 different salons on the same high street and send a substitute into each one. So he could theoretically become an employer and actually send people into different areas. So, for instance, you could decide, if you're self-employed or renting a chair, that one day you go, well, actually, I feel like going shopping today. I'm going to ring Sheila and she can just go in and do my work for me. Gareth's got it's called an unfettered right to substitution. What that means is she cannot be interviewed. She cannot have a CV checked. You know, she could have public liability, but there's no way that she could actually be, shall I say, go through any kind of onboarding process.
So
and you can send her in whenever you want.
And I think the interesting one, and I see this a lot, which is that when a trade test is done for somebody coming in to rent a chair,
that there's been cases that have actually failed on the basis that somebody had an interview and a trade test.
Exactly, because
and the advert. That's the advert.
And this is the disadvantage then for the salon owner, which is that effectively, you know, what you're trying to do with the trade test is make sure that your brand is protected, because you want to have control over the quality of the work that's done at the end.
But you can't, because you're not supposed to be servicing the clients from the salon.
There you go. And so you're servicing your own clients.
And you should be able to distinguish it like this. HMRC like to be able to stand outside and say every self-employed person's got a red hat and every employed person's got a yellow hat. It doesn't work like that. But if you go into a shopping centre, would Boots tell Marks and Spencers what to do? You know, you've got to look at it like that. You've got to look at, you're doing your work, your landlord walks in and goes, right, okay, I want you to stop working on that person and go and do this. If you see what I mean, you've got to look at it from an outside point of view in order to determine correctly.
Thank you, Colette. I think this is a really important one here, and this is linked to financial risk, which is that you manage your own client, your own marketing, your own client list, and your own business admin. And so, but by that, it means that effectively the clients that you do as you're self-employed are your own clients for which you have generated. And it doesn't matter how you did that, whether that was social media, email, paper flyers, if you still do that. Actually, you are responsible for generating your own clients. You're
Therefore,
not reliant.
You can't
on the
take
shop.
walk-ins either, can you? Can you?
You can take walk-ins, Sheila. But
you can.
You supposed to have a menu in reception. Say you've got 10 people working in an environment.
Right.
In reception, you're supposed to have a list of everybody there, all their insurance details, all their company details. Okay, and that's supposed to be displayed so the public can select who they want. You're supposed to have a menu for each person on reception, like a takeaway menu. So coming back to this, what you just said there, And then the idea is, Sheila, that it's got to be offered out and anybody can go in. Do you know what I mean? It's not got to be determined by somebody controlling. Gareth, I'm the salon owner, you can do that client. I've now controlled you, you're therefore employed. On the marketing and the own client list, now this is really important with the client list, because there's been something recently. Sorry, Gareth, I just have to put this in because I think it's important, which is something called DAX 7 reporting. So this is digital reporting. You've probably all seen it on the news with Etsy, Deliveroo, eBay, how they have to report all the income from those platforms now to HMRC. Well, that actually goes through to systems like Fresher, Booksy, digital reporting platforms. And at January this year, they reported all the previous year's details and transactions to HMRC. So where there was over 30 transactions or £2,000 trading activity for purchases of products or services, they had to report them to HMRC. So now HMRC have pretty much a catalogue of everybody's earnings, and they then check that against self-assessments.
And that's a really interesting point, isn't it? Because this is the business admin point, which is that, you know, it seems very easy to use the salon's booking system. You know, you're on the salon's website, you go through their system, the client, you know, the price list almost, you know, is what it is. You know, and that then is problematic because you are not managing your own client list and you're not doing your own business admin.
Yeah, and that fails a key point, Gareth, which is the second Achilles heel. I'm going to call these the Achilles heels. These are let's call them the box collar bombers, you know what I mean? Because that's what we hate. So this is where one of these comes in. This is called mutuality of obligation, or MU as a cow, okay? And what this means is if you're actually servicing clients, that the clients rang up Gareth's salon, doesn't even know you, has never met you, or not contacted you directly, and I say I want to book in today, and Gareth just books me in with Sheila, that means that mutuality of obligation has failed. So what mutuality means, you've got to be there because I booked somebody in for you, okay? And that's really important, because that's one of the fundamental tests as well. Who actually owns the client data? Not to mention on the business admin side, GDPR. And we have a lot of clients at the moment, or salons and individuals, who contact us because they end up leaving the business for some reason, moving on, and all of a sudden the client list, who does it belong to? And it starts to break the relationship down.
And that's a really important point, Colette, which is that when you are employed by somebody, the client list is owned by salon owner, by your employer. When you are self-employed, they are your clients. And that, you know, that's an important differentiation. You mentioned about day-to-day control. I think that's exactly that. You decide how the services are carried out.
Or if you wish to issue, you can, if you wish to refuse a service. So that's really important.
Yeah, really important. That's right. And that goes back to your point about somebody's just been booked in for you. Okay, so that is the indicators you're truly self-employed. And I would, okay, so Mark has asked a question. So is it true, this also means that for mutuality of obligation, that if one self-employed books a client, which is a walk-in, with another self-employed, as a salon owner, they've created a mutuality of obligation. So you've got a triangle here, Mark, is what you're saying.
Yes, you have. You have created it if you share services as well.
You're absolutely right. You are causing problems for all of those three people.
Yes, all three, because as well, the other thing is as well, a lot of people believe they can share services across people. You can't. And this is where it gets really tricky, because, and this is based on, people will say, well, look at the rules, you know, but then you've got to read case law, as I said, because laws are set and then case law sets the pace, if that makes sense. You know, so on case law, people who've actually, let's say, for instance, a judge made a judgment based on somebody sharing, Gareth and Sheila shared a client. Gareth and Sheila shared 6 clients. They're clearly employed. That's the problem here. So the idea is you've got to imagine an invisible box around you, and that's where you're working. That's why America went to booth rent, because they had the same problems. They couldn't distinguish where were the operating grounds. So just saying for Mark, which then means that without realising it, you're self-employed or just helping each other out, or creating a very large legal issue for you as a salon owner. You can't control it. Absolutely. And we've seen some cases quite recently on this, where salon owners have actually, and I think there's going to be more, especially with the digital reporting, where the salons actually, or the VAT, I've got 3 cases at the moment of salon owners who've actually had backdated VAT bills who are now suing the renter chairs for the VAT.
Yeah, because this
gets really tricky.
And I think, you know, what we are indicating here is that it is quite difficult to rent a chair and meet all of these requirements. And we've only covered off about 10 or something of the 100 odd because they're most relevant to our sector. It is a high hurdle to pass, and I think one of the main issues that's affecting us as a sector so much is the view that, well, so and so is doing it, so it must be okay for me to do it too.
The other thing that comes up, Gareth, quite often is I had a VAT audit 10 years ago and I was fine. You could smoke in a pub 20 years ago. You know, you could ride without a seatbelt. You know, the point is laws have changed. The difficulty is that just because somebody was checked 10 years ago doesn't mean if it were checked today it would be okay. If you were checked for VAT, and I'll give you an example, or tax, if you were checked on national minimum wage or VAT on April the 5th, 2020, and I was checked and I said, Gareth, you told me you were self-employed. HMRC said, Colette, what did they say? I said, Gareth said he's self-employed. That's okay, I can walk away. April the 6th, 2020, the law changed, which meant that I had to determine Gareth's status. Okay, it happened during a pandemic, so nobody noticed it. And what happened then was, I then have to go, well, if Gareth's working for me all week and nowhere else, Gareth's servicing the clients, he's using my resources, I'm buying his colour. Do you see what I mean? It all points the same way. And they only have to see one arrow pointing and they'll just dig and dig and dig and dig and dig.
So Paula, the VAT threshold is 90,000. Okay, so indicators you should be an employee. So this is looking at it from the other way around. So the salon sets your working hours or requires you to be on the premises at specific times. So you can see that's the opposite of I can come in when I want to, I'm now told when to come in. The salon controls price discounts and how services must be delivered. Because you are under direction, and as an employee, we are expected to be under direction. All of us have a boss. However,
and at home, Gareth.
Well, that's my exactly. But
sorry, I had to bring that one in.
But even so, you know, all of us in all organisations, whatever the structure, have a boss. It could be your shareholders. It could be your directors.
It could be your employees.
It could be your employees if you run a model which is an employee trust. So, you know, very much you are under direction. I think I would add to this the working hours about holiday. And I hear all the time where, for example, somebody is self-employed being told they have to be in the salon during December.
Or they're given rent-free periods, Gareth. That's a massive, massive red flag. What happens is salons will generally say, oh, you can have 4 weeks rent-free, 6 weeks rent-free, because, you know, we're busy mates or whatever. But the point is that indicates holiday leave. So when that's examined, that very much looks like, talks like, sounds like, and quacks like a duck, if that makes sense. So that points to employment.
However, that is different to, for example, a period at the beginning of, let's say, 3 months where your rent might be reduced or zeroed, because that would be a normal commercial arrangement that any landlord tenant may negotiate when they come into a premises. What you're talking about, Colette, isn't it, is like annually you get August, for example,
yeah,
when you're
I know.
not expected to pay rent.
Yeah, and even the rent-free, even if there was a rent-free period, that would still be tested, Gareth, to be fair. And it may not actually pass the quota because it's a big indicator that you're still employed. And just like any commercial arrangement, you would have to have, you know, you'd have to have some form of you know, license, contract and everything else in place with that. And I just think it opens up, you should be able to say, if anybody checks you, the rent's paid 52 weeks a year or whatever it is, whenever somebody's here or not.
And as Mark rightly says, it's an indicator of risk, isn't
Yeah.
it? Rent
Yeah,
is
it
a
is.
great
It's-
indicator of risk.
Just depends what
And-
risk you want to take.
And that kind of leads us to a really interesting question, which is the way in which self-employed pay their rent, because it's terribly common for there to be just a turnover split. Let's just say 50-50 for the minute. So, and I think, you know, we all know what that means. I have some serious doubts as to whether a turnover split alone passes the test for self-employment because of the risk. But go on, Colette, you're going to correct me there.
No, I'm not going to correct you. Look, there's no yes or no on that, Gareth. What it's about all the contributing factors with it. So if you had a percentage split or whatever else, you know, because some landlords do actually take a percentage of turnover to actually satisfy a lease. The difficulty here is you have a percentage split, but then how can that self-employed person ever make a loss? So it just depends. When they look at the other contributing factors, I think that would give them a massive indicator towards employment at the offset. And it's
because
like
you pay 50-50 and you don't buy your own product.
Then it would.
There's no risk.
Then it would point to employment.
Yep. Yeah. Exactly. So there we go. Salon provides all the tools and products, and you simply turn up and work.
Yeah.
I must apologise. I've got the full stop on the wrong place there, I think, haven't I? Oh no, maybe not.
Don't worry, Gareth. We've not got the grammar police here this evening.
You have to follow salon rules. Wear uniform or are supervised.
That could just be saying wearing black, Gareth. I think it's really important that there's a recent judgment, and it was HMRC and it got put out. Sorry, Gareth. He hates it when I'm on the subject. This judgment actually proved the person was employed because they were wearing a salon gown with a logo on. That was classed as actually being part of a team and actually advertising the salon. That showed that they were working on behalf of the salon. So the client was wearing the gown, not the person wearing the uniform. The client was wearing the gown.
Yeah, and again, it's the accumulation of the checklist here, isn't it? Is that we're talking about. Should be an employee, can't work elsewhere, or take your clients with you when you go. We talked about income. You're paid a set wage, fixed commission, or you've got a guaranteed income. And this would also fall into where you know, as the salon owner, you might like give a worker, somebody saying they're self-employed, you might give them sort of a break from their rent for a period, or you might give them an extra bit of, you know, I only take 30% off you this week because I know you've got some expenses, you've got a holiday coming. And that, again, is all about the risk. And Colette's favourite, you're not allowed to send a substitute, which we've talked about. This is a really interesting one, I think, about complaints. Because if you are self-employed and somebody is unhappy with your service, they come to you directly. If you are an employee, they go to your boss and complain. I mean, that's the same as we go into Costa and our coffee isn't quite right. We ask to speak to the manager. And I think this complaints issue is one that is probably slightly falls under the radar a little bit, but I think it's really quite important. Okay, so if most of these apply, legally, you're likely to be an employee, even if the salon labels you as self-employed. And I think, as we've said, it is very difficult for many people who are renting space in a salon to satisfy themselves 100% that they meet all of the requirements. And you might not meet a few, as we've said, and still you can be self-employed. Let's be really clear on that. But it is the totality of of the relationship between you and the engager, the salon owner, that is important. You know, if we look at a lot of Sheila's clients who may work not in a salon environment, actually it's a lot easier to fulfill those requirements that we've talked about. You know, if you are, you know, because let's say you're working from someone's home, you've got all of the boxes are ticked about product, about risk, about who owns the client, about booking point, you know, the whole thing. You are, you meet all of those requirements, and there really is no question at all. So why is it important? As Colette started with, working status is based on the reality, not what a contract calls you. So it's terribly easy to get a template contract from the internet or from one of our advisors that I mentioned at the outset. That's just generic, and you think that it meets it's okay, tick box, tick, done, thank you. But actually it absolutely needs to be based on the reality in your working location, because if it isn't, you are opening yourself up immediately, because really the contract, this employment, you know, this contract is the start point for everything.
I mean, the other point is, Gareth, it's a really difficult one. I know some incredibly good lawyers, as you know. Lawyers will not write you a rent-a-chair agreement. Lawyers will not write you an independent contractor agreement, because they know that and when we actually look at these we've seen them in tribunals and how they've fallen. And when I say falling or failed, because the relationship's tested. This is the problem, because when you have a piece of paper and you believe you're working within that kind of remit, look, we all do it. I'll put it another way. It's like putting an IKEA wardrobe together without reading the instructions. I do it all the time. I don't read the instructions, I must admit.
What instructions?
Never read the instructions.
As a man, I'm incapable of reading instructions.
Yeah, but it's the same thing. So the point is that what I'm trying to say is, if you actually were genuinely 100% genuinely self-employed or renting a chair, then it would be a license to occupy. The other thing for salon owners, if there's any on the call, you would actually have to seek permission from your landlord. Okay, you'd have to have a right to sublet in there, okay, before you can even do that. Some salon owners have actually, you know, had some issues there. Sorry, I'm very factual. But the point I'm making is, please, 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 if you are a salon owner, you get specific advice based on your salon, whether you're an employer or you're a salon owner renter. And if you're renting a chair, you make sure that what you're signing is actually the reality of your relationship. Otherwise, you're signing away 28 days holiday, all your employment rights, and everything that goes with it.
All those things. Holiday pay, sick pay, minimum wage, pension, and protection from unfair dismissal.
You also can't be working as in a salon as a stylist one day and be told when you come in on Monday you'll be self-employed. There's a huge, you know, it can't happen overnight.
No.
I think that's a really, really good point, Sheila. We see it all the time where, you know, and it can be because the employer feels they can't compete against those that don't pay minimum wage, that don't pay employers' national insurance, who don't qualify for VAT. And that's a real structural issue, which I think hopefully most of you know. You know, we've been lobbying really hard. These three organisations, Salon Employers Association, Fellowship, Men's Fed, and Habia, under the umbrella of the British Hair Consortium, have been lobbying really hard for those structural problems to be addressed, so that it isn't tempting just for financial reasons.
Yeah. And if I can give you a recent, if I can give you an idea of a recent case, which they're just going back to appeal. Sheila, you're exactly right. You know, a lot of people will tell you this is where the difficulty is, because of employment status and because of employment law and tax law not having synergy. So the reason there's no synergy, because you might think that's ridiculous. Why would you have two things that don't agree? Well, you know, here goes. So on employment law, you've got three statuses. You've got employee, worker, and self-employed. On tax law, you've got employed or self-employed. So employment law's got an extra person here, or an extra category. The Employment Rights Bill is going to bring them together under what's called single worker status. So they're aligning that. But to give you an idea of just how this works, there's two famous cases, but I'll give you this one first. This was even before the law change of employment status in April 6, 2020. And this is Matthews versus Razor's Edge. And what this was is, sounds awful, but everybody wanted to go self-employed. Can't blame them, you know, that's the way it goes. People want to try it. So the salon owner agreed, they all went self-employed. 18 months later, one of the relationships broke down and the salon owner was sued for employment status, and all of them won. I think the highest payout was £71,000 for one person. So they won their backdated holiday pay, all their pension, national insurance contributions, and they won national minimum wage for every single blank space they had in their diary. So it came to a lot of money. But what I'm saying is that's the danger of switching. If you actually do that, you've got to satisfy some pretty big rules. A lot of people say, and organisations have even said, that you can actually have a break in service of a week, a weekend, or 2 weeks. No, you can't. Under TUPE regulations, you've got to have a break in a minimum of about 12 months. So she would have to leave my salon, go and work somewhere else for 12 months, then reapply to me. Well, not apply, but actually come and say, I'm renting a chair.
Yeah, and the important point there, Colette, isn't it, is that it's not saying you can't go and work elsewhere.
No.
As either as an employee or self-employed. What it's saying is you can't just pop from one to the other.
It's not a choice. Employment status is not a choice.
So, there's just a couple of the kind of main things here, which is, you know, chair rental means I'm automatically self-employed. No, it doesn't. You need to show genuine business independence. Or I pay my own tax, I must be self-employed. No, HMRC looks at control, risk and substitution, not just who pays the tax. You've mentioned about the contract.
Yeah.
If it says I'm self-employed, I must be.
No.
No, if the reality differs, it's the actual working relationship that is the important point.
Yeah, I mean, it must be absolutely awful for people out there because, look, you know, we get a lot of calls, and I've passed them to Sheila, bless her. And as Sheila gets a lot of calls on this, and it's very difficult. But, you know, I had a recent call from somebody, and I actually couldn't believe what I heard. So this person believed they were self-employed, but when they were employed, this moved to self-employed, but when they're employed, they had to pay the employer their national insurance back in cash. So they had to go to the cash point, get out the national insurance and give it back to the employer. And then they changed the contract to self-employed, but nothing changed. Nothing changed. Same client, same day, same number, same name over the door, same chairs, same backwashes. That is disguised employment.
Yeah, I mean, that's just so not okay.
No.
So we're gonna move on from self-employed versus status versus employed status now, and look at some of the recent and forthcoming changes to the Employment Rights Act that come in on the at the beginning of April. So if anybody's got a specific question about the self-employed status piece, please pop it up now. We can always cover it off at the end as well.
And ask anything you want. I don't know the lottery number,
but it's a really good opportunity before we get into the Employment Rights Act.
It's very difficult because for a lot of people, if you don't understand this, and you're doing it genuinely for problems that you think is going to get you out of trouble, without looking at what we're talking about this evening, you're going to fall into trouble. You've got to have this information. You've got to do it right to avoid getting yourself into deep doo-doo.
Yeah,
that's very nicely put, Sheila.
I love that.
But you're right. It is, you know, this comes back to, you know, the thing I said a bit earlier, which is that just because everybody else is doing something, that does not make it legal. And you could look at that about drink driving. Everybody in my town drink drives, so it must be okay.
No.
You know, it just isn't. So
Can you put
So
the money
Paul-
through one till or share it? Right, this is the difficulty. Sorry, Gareth, I was jumping in then.
No, go.
So can you put the money through one till or share it? There's difficulty here because in the rules it said it can be distributed as long as it's done in a very reasonable period. However, there's something called VAT disaggregation, and what this is, it's actually classed as evasion to split income at any level. So what this means is, and this is why they're putting the digital reporting and everything else, because what they're doing is they're looking for actually where the income goes into the business. So let's say, for instance, I'm Sheila's hairdresser, she's the owner. If your income goes into Sheila's bank account, then Sheila, it should be paying VAT on that. It's going to be classed as Sheila's income. That's where it gets messy. If you want to do, if people want to do this correctly, make sure everything's separate. You should be able to walk in there and have no association with that salon owner at all. In fact, they shouldn't even have a name above the door. You can't trade under that name.
Yeah, but it is a difficult one because
it is a difficult one, Gareth.
Some of the tech systems now, for example, allow you to pay your own license to be on a particular branded system, and the money goes into your kind of part of that.
But they have got access to that. And as I said, I've had a salon owner who said my merchant card services were, because they do have access to merchant card services as well, all of them. So my merchant card services said I turned over 210,000. I haven't, because I rent chairs. I turn over myself 45. Doesn't wash. It's still been classed as that income. And I think you'll see that the problem is, Gareth, it's nothing to do with self-employed or employed. It's to do with money laundering. And that's one thing they'll be closing down very quickly.
Absolutely, but it's Paula, it's a really good question.
It's a brilliant question, Paul. I love you.
Because as we become more digital in all of our payments and all of our business relationships, actually the question about who takes the money is becoming more and more and more relevant.
TUPE doesn't apply to self-employed, it only applies to employee. It's transfer of undertakings to protect employment. So it doesn't apply to self-employed, because if you're self-employed, you're not part of an organisation, unless if you're in a self-employed position and the business is being sold, then I would look at testing your own employment status. You can do that on HMRC's website and check your own employment status.
So I think it's just worth quickly mentioning, just for those of us that aren't quite so clear. So a TUPE is a transfer of undertaking. So it means that if I sell my salon, which has got 5 employees to Colette, all of the terms and conditions of employment that my 5 workers have got are transferred to Colette completely, whether that is the same as the staff that Colette already employs have. So the transferring of undertakings is a really important thing, and we see it, in huge organisations. When the bins are collected by Biffa instead of somebody else, all those workers have been TUPE'd across.
And just under the TUPE as well, and the contract side, you cannot have any change to your contract unless, if you're over 2 years service, it's got to be by consultation and disclosure. What that means is it's got to be discussed with you, and you've got to agree it first.
I think that if you're into TUPE, you need legal advice. Bluntly,
you need to contact one of us.
Yeah, so you need some proper advice. So
yes, you do. Yes, Mark, you're right.
Yeah, Mark, absolutely right. It's this, as we keep mentioning, it's the kind of the checklist of things that point towards what the true circumstances are. So absolutely. So Monica, you need to test yourself So I'm assuming from this, Monica, you're taking over a business, and the workers in that business are self-employed. So absolutely, you need to be completely comfortable with the working relationship between you and those new self-employed people.
If Monica needs any help, she can contact me directly, Gareth, and I'm sure I can point to somewhere on that. I think it's really important here, Monica, because depending on how you're purchasing the business, you're purchasing everything from the business, if it's a limited company or sole trade or whatever. But Gareth's exactly right. You then determine, you take over. It's just like a baton, you pick it up. So it's best that you test. You don't just test yourself, you test every person within the business. What that means is you put their true relationship through the CESS tool. So the CESS tool is basically it's a survey on HMRC's website, and it churns out the other end whether you're self-employed or employed. But they don't stand by that, despite what people say, because they'll just say that you've answered it correctly. But if you want to reach out to us, Monica, we can certainly help with that to make sure you've dotted the I's and crossed the T's.
Yeah, I mean, Mark's point is really valid there, and we'll just
the goodwill.
We'll move on to the employment rights stuff because we're running out of time in a moment. But Mark's absolutely right, and this
You're
is
not buying
around
the clients.
the value of what you're buying, because all of those clients for the self-employed people are theirs, and they can decide to up and move. And it's for this reason why Colette and I were lobbying the government really, really hard to allow the non-compete clauses and the non-solicitation clauses to remain, because the government would like to get rid of them. And the problem is, if they get rid of them, we believe that you're removing a lot of the value, the sale of a salon, because it's the clients that provide the value.
That's right, and that's your goodwill. So this is the problem here. And Mark's exactly right. You're buying the bills and the lease, because you could go into that business and they all move the next day and they take all the clients with them. I just think Monica, just reach out to us. Let's have a discussion.
Yeah. So this is one for Sheila. So Anata says, I've got FHA insurance. So do I still need public liability insurance? Sheila, you can answer that.
You have got it. You've got public liability and treatment risk in the whole. It's all covered in one policy.
Perfect.
So
thank you,
if
Sheila.
you want to speak to me about it, please do. But I can assure you, you've got public liability and treatment risk for yourself.
Okay, so Monica's buying the trading name. Okay, I just make sure that asset split has not been included in any way, and get a good lawyer to look over your agreement.
I think you raised something very important there, Sheila, which is about treatment risk. And it's worth just checking your insurance, because if you're self-employed, you need your own insurance, of course.
100%.
However, a lot of particularly very cheap insurance policies are actually not fit for purpose and may not include treatment risks for the things that we do.
It's like when you had your XR3.
You're right, Gareth. A lot of people understand they need public liability insurance, but they don't know about the treatment risk. And our membership automatically gives them insurance cover that's correct for what they're doing and where they're working.
Yeah. Perfect. So your public liability is your trips and falls. Treatment risk is obviously all your treatments, but it's just like when you have your car and you have to tell them if you've got a turbo. That's what I was saying, Gareth, when you had your XR3i, if you ever had one. And you go, no, I never did, Colette. Did you? Oh my God, did you have a big course on it? Anyway, but the point is, you have to tell them every single detail. So the treatment is really important. Sorry, Gareth.
That's all right. So we can come back to some more questions at the end, and I'm happy, and I know I'm sure the others are as well, to carry on answering questions as long as possible. But I'd quite like to cover off the Employment Rights Act
really important
stuff just in sort of the next 10 minutes. So these things come in on the 6th of April. This was a manifesto promise by the Labour Party, and the things have changed and have been watered down considerably in the last 2 years. However, you get a day one entitlement to paternity and parental leave. So we'll look in a bit more detail to each of these in a minute. You've got reforms to statutory sick pay, sexual harassment count as whistleblowing, the setting up of a Fair Work Agency, and then 3 others, of which one in particular I want to talk about in a moment, which is about the changes to rules on trade union recognition. Obviously, the other 2 here are for larger employers, by which you would be, frankly, definitely employing a lawyer. So, paternity and parental leave. This means from day one, they have a right to paternity and parental leave instead of 26 weeks for paternity leave and 1 year service parental leave. So you need to change your employment contracts to include this. So there's a little bit of detail here around the notice, because of course there is a period of time now where the notice doesn't necessarily work. It's the same as for ladies with maternity leave for the 15th week before the due date, and the flexibility, and this is an important one and can be complicated, about the restriction on taking paternity leave after shared parental leave is removed. Now, I'm probably talking and everybody's glazing over slightly about this. Paternity and parental leave is quite complicated.
It is, yeah.
You need to make sure you've got these clauses written into your contracts to make sure that, you know, when it happens, and, you know, paternity leave, shared parental leave is becoming much, much more common, and it's a really good thing.
It is a good thing. And the other thing is, Gareth, as well, you just mentioned on the contract side. I think what's really important as well on this is to make sure that, you know, you've got your contracts, but you actually have another thing, because there's protected rights here. And this is why these are important, because of the heaviest kind of liability, if that makes sense, if they ever went to tribunal. So on the maternity and paternity, but on maternity particularly, and making sure your health and safety is in place, making sure you do those risk assessments, making sure you've got everything in place, because the protected characteristics are just that. And what that means is if somebody's got particular, you know, medical conditions, disabilities, or the, obviously, you know, with child, how to say with child, then obviously they are protected under these laws.
Great, thank you, Colette. Reform statutory sick pay. Now, this is where it's probably got the greatest headline. So basically, this change means from the 6th of April, you have to pay statutory sick pay from the first day of illness. Now, statutory sick pay, you don't get this back from the government. Used to years ago, and they now give us the employer allowance, which is, you know, was introduced by George Osborne and is now £10,000 and has changed its purpose. It's now almost like a
that's only applicable against national insurance.
Yeah, exactly. So, you know, this statutory sick pay is not something you claim back. And so this could potentially be quite a financial burden. But
the other thing is, Gareth, as well, people don't need to worry about this, because your payroll system will be updated at year end to actually rework the statutory sick pay. I doubt if anybody does it manually anymore, because those books used to have were just crazy. Or your accountant will do that. But your employment allowance, just when you just said, Gareth, it's really important that you make sure you put that claim in, because it doesn't automatically do it sometimes. Therefore, HMRC don't get the notification. You don't get your employer's allowance.
Yeah, you've got to tick the box on your payroll software. Again, whoever does your payroll, make sure. Just, you know, we're in the last month of the year for payroll now, so come the beginning of April, it will start again. Just double check. Just one very quick one on this. I was asked this morning whether SSP is calculated per day someone is sick, or per hour if they don't work full days, or whether you've got to give somebody the whole 123.25 a week, however many days they are off. And statutory sick pay is paid for the time you are off only, whether you're an hourly or a week, full-time days work.
Payroll systems calculate that anyway, Gareth. They have a system.
But just make sure you update your policies in your contracts. Sexual harassment. So this is what Colette mentioned about protected disclosure. So this basically means if somebody makes a claim of sexual harassment, they are protected from unfair dismissal whilst they are reporting those issues. And really, this is most employers, this won't affect, because most employers, well, firstly, most employers aren't into sexual harassment. And secondly, most employers, if there were a disclosure like this, would act in the correct way.
But Gareth, you've also got to make sure you've got policies in place to protect your employees when they're actually outside of your environment on work business. So if they're training at an establishment or anything else, you have to have a policy in place. Should they raise a claim with them or an issue with them, those protected characteristics still stand.
Yeah, absolutely. Thank you. And I think, it's a really interesting point, particularly for those that work alone, they're remote workers, around the safeguarding from sexual harassment. Of course, you might work on your own. And it's really important that if you do work in that environment, you have put in some steps to ensure that people know where you are.
Yeah, location, buddy system, anything like that.
All of those things are really important. Please do it if you haven't. So Fair Work Agency, this is really
Massive.
important. Really
This is
important.
huge. Yeah.
So it's yet another quango, you might say. However, the Fair Work Agency comes into force on the 7th, so we've got an extra day. And basically, it acts as a one-shop stop to enforce employment standards, protect workers, minimum wages, gangmasters, sick pays, and those sorts of things. And it brings it all together. So it tightens up the rules. And the key point for us, we believe, is that the Fair Work Agency will now be the go-to body to look for self-employed models, particularly things like collectives or rent-a-chair. Hence one of the reasons why we're doing this webinar now, because without a doubt, both self-employment in our sector and in others, and the enforcement of things like VAT is on the government's radar. HMRC were given multiple billions of extra pounds for enforcement at the last two budgets. And so the Fair Work Agency is a big part of this enforcement of the rules. So please, if you're not sure about your status of the workers where you are, please do something about it. Please don't just hope and wait.
The other thing is, Gareth, just to say to people that they don't have to let you know they're coming either. They can just access.
They can just come in. That's right.
So don't be alarmed if you do get a multi-agency visit, because that's quite normal. You will generally get, because obviously they're really on this at the moment, and they intend to go with some force from April 1st, because that's when they go into operation. But they usually come under a national minimum wage check, because that's their key area, and they will be looking for obviously disguised employment, because that's what they're looking for.
Yeah, and the national minimum wage check is the key, because if somebody's self-employed but shouldn't be, they hammer you for national minimum wage, and that's the starting point.
Yeah. There's a question here, Gareth.
Yeah, go on.
Yeah, so Anita, hi there. If you are self-employed and pregnant, for example, are you under any protection by your insurance, or you need to pay some separate insurance? Right, okay, so I don't know if you mean there about treatment at risk or your insurance when you're actually servicing the client. It's similar to when you drive a car. There's usually, you've got to inform them at a certain stage, and usually driving's from 36 weeks. They don't want you to drive. So it just depends on what services you do. How long can you work when you're a pregnant hairdresser? You can work whenever you want to finish.
Till you drop.
Yeah. I actually work past my due date with my daughter and my son. So, or is it no rules for it? Because self-employed have no paid for time off. You do actually have rights to maternity pay still for self-employed. So if you're self-employed and you've paid your national insurance, you can still claim statutory maternity pay from DWP.
Yeah, it's called maternity allowance.
It is, yes.
You complete the form online. It's exactly
it's not
the same
a silly
amount.
question either. It's a good question, Anita.
It's a really good question. It's almost the same amount of money as statutory sick pay.
It's exactly the same as statutory sick. It's the same as maternity pay.
Yeah, but you just get it from the government direct instead of through your employer.
Yes, correct.
So I also mentioned about the trade union changes. And the important thing, I don't have a slide on it, but the important bit about the trade union changes that is coming in, and this will probably impact larger employers first, but will trickle down pretty quickly, is that the changes to the unions means that a trade union now has a right to come into any workplace with our employees.
They believe there's employees.
Or believe there's employees. Yes, exactly. And unions can do some really amazing things, and they can absolutely be a massive power for good. But it's important you're aware that this right exists. Now, they're very unlikely just to turn up on the doorstep and demand access to your premises. And frankly, if somebody did that to me, I would firstly ask them who they were and to prove it. And I would then book an appointment with them for them to come back at a more convenient time when I didn't have clients, because you're running a business that they may not understand how it works, because hairdressers and hairdressing has never really been terribly unionized. And so they may not understand that everybody clocks off at 11 o'clock for a cup of tea and a digestive. So that's a great time for the union rep to come and explain things.
Who clocks off at 11 o'clock for digestive and a cup of tea?
I'd love
No
to.
hairdresser drinks a cup of tea.
No,
It's always cold.
Exactly. So I think there will be more details on the union access shortly. We'll make sure we publicise it. Okay, so just before we finish off, there were some changes today about apprenticeship funding. And when Colette, Sheila and I wrote this last slide at 7 o'clock this evening, this is our understanding as it is right now. However, the devil, as we say after every government announcement, is in the detail, and there are more details coming about this. So firstly, £3,000 for each unemployed young person you take on as an apprentice.
These are grants, by the way. These are grants, so not loans, by the way, everybody.
Yeah, it's a grant. But there are specific requirements for the £3,000 grant, because this is targeting directly the not in employment education or training, called NEETs. And they must have been claiming universal credit for 6 months. Government expects 60,000 young people to get into work through this scheme in the next 12 months. So actually, it's quite a lot of money across 60,000 people. It's quite a lot of people. The reason we're saying more detail is we just need to absolutely confirm that we are included.
Well, details always in the legislation document, Gareth, as you know. So
yeah. So secondly, and this is separate to the £3,000. So apprenticeship incentive payment, which is £2,000 for every 16 to 24-year-old hired by a small or medium-sized business. And we believe that you can claim both, but of course, you need to be an employer, because only employers take on an apprenticeship. Sorry, an apprentice. You're going, Colette.
Apprentice. So the other thing on these, Gareth, is on the 3,001, it's actually fully funded cost employment. What that means is they will pay the young person's wages up to 25 hours a week. You can employ them for more and pay the difference. And that's for 6 months, but obviously you have to pay it before you claim it. So there's the old adage with cash flow, and they'll also pay any national insurance for that person. But there are strict criteria on this. So not only have they got to be unemployed for 6 months, they've got to have not done 50 hours work in the last 18 months. They've also got to be under special requirements. Special requirements people will go first. That means people who have got protected characteristics themselves. You can actually do the job youth guarantee prior to taking somebody on an apprentice. So it's a good 6 months test, and it's a good way to actually get somebody in and actually trial them for 6 months with no cost, so that you can trial them before an apprenticeship. But obviously they've got to rely on the fact they've been unemployed and on universal credit for 6 months. So that's
and the issue is, I think, that people who are NEETs are normally neat for a pretty good reason, as in,
yes, they are.
And so this is not, you know, you've got to be mindful here that you have to put the training in for this person. This is not just a case of getting somebody who you would otherwise normally have taken on and getting some more money.
No, it really isn't, Gareth, and not just that. It's so they're looking to try to place prisoner releases and stuff like that as well. So I think
and that might work for barbering.
It will work really well because, you know, not everybody's a bad lad, really, are they? Some people going for different reasons. You know, so with, you know, but anyway, so on this as well, there's up to a £250 add-on onboarding grant for any additional costs. But again, it comes through a deliverable. It should be proposed to you by any training providers if you work with them, and they actually put people forward. See how it goes. But it's only that one is only in specific particular areas at the moment for phase 1. They're rolling it out later in the year for other areas. It currently includes, I believe, Birmingham, Southwest, Northwest Wales, East Midlands, parts of Scotland. There's a list of the boroughs that it actually includes.
Would there be any link with this and where those might be constituencies the Labour Party aren't doing so well in, Colette?
I think it is, Gareth, yeah.
Oh, no, there's me being a cynic again, isn't it? Brilliant, thank you. We have had a few questions as we've gone. Has anybody got anything else at all that they would like to ask us? I think if hang on, I think Anita's typing away here.
Do you know what though? It is interesting, isn't it, in business and work, because you just go along about your daily activities, and then somebody calls the government, comes and moves all the bloody goalposts.
Yeah, I mean that's exactly right.
We just want to do hair, Gareth. We just want to do hair. Sorry, I'll just say one for everybody. Sheila's going to be in a minute off with her head. On Sheila.
Yeah, we'll just. So I mean, I think that there is. Do I need to pay tax on maternity money? Yes.
If it's over the threshold, yes, you will. If you just get maternity pay, then that will be under the threshold. But if you've got additional income, including pensions or anything else, I know you're not old enough for that, but I'm just saying, you never know. Then you will have to pay tax on that. So the current threshold is £12,570 a year, but it may be high depending on your situation.
Yeah, basically, if you're self-employed, it's got to go on your tax return.
Yes.
That's as all your income needs to. So
the other thing we've got coming up, and I think we ought to do another one on that, Gareth, which is Make Tax Digital. So you
love that.
We've got an open meeting on Instagram on Thursday evening on Tax Going Digital.
What time's that? Yeah. Because we've got
7:30.
Oh, we've got a cohort at 7. I would have loved that.
Open to everybody.
But you know what? Make Tax Digital is not as scary as it seems if you've got the right advice. But at the same time, depending how many income streams you have, because you have to do one return for each income stream. So.
Yeah, and I think it's one of those things that's it's been coming for some time.
They've put it off for about 4 years so far.
I can't see it being put off again. So,
no, it's not being put off. It's in. It's in.
But yeah, we've been having people come and talk to members for the last year or two.
I know.
Now we're sharing it out there for everybody to see what goes on and to help people.
And do you know what? That's brilliant. You've done that, Sheila, because we've talked about this for some time, me and Sheila, and Sheila's really helped her members by making sure that they understand this well in advance, so they're not particularly worried about it. All the Sheila just cracking on.
So Monica, I can absolutely send you the recording and the transcript. We can test how good AI was. Let me just double check, Monica, before we all go, that I have got your email address on the registration.
But equally, if anybody's got any questions, they can reach out to us. Okay, we're always here to help. That's what we're here for.
Absolutely.
And any concerns or anything.
I do have the your email address, Monica. So yeah, absolutely. I can pop this up on YouTube, and I'll just share the link with everybody here, so you can do this. But again, let me reiterate: we're not offering legal or tax advice you need to go and see a professional who understands our sector.
Yeah, I think that's really important you say that, Gareth. As an accountant myself, I speak to a lot of accountants, and with all respect to that sector, because I've been a hairdresser for 14 years. What I will say is not a lot of them understand the sector. When you go to see an accountant, they're there to tell you your tax position and deliver what you've given them. They don't actually understand the inner workings, so they take it as gospel. Everything you've given them is actually accurate. The second thing is there's always a disclaimer at the bottom saying we're not responsible for anything you've actually given to us.
So yeah, if you Anita, you wanted my email address, it's just there. Please, oh sorry, Monica, I think you did. Sheila, just pop yours up in the chat as well.
I'm just doing that, yeah.
And so then it'll kind of all go out in the thing, but it is on the, from memory, it's on the back page of the slide as well. But if you can't reach out in that way, just get a hold of us through the organisation. So either through Hairdressing Council, FHA, or SOU.
Yeah, and if any salon
contactable.
Yeah, if any salon owners or anybody else wants to dive into any detail and really understand, where they're at, and that doesn't matter what salon you operate, we're here to help you. Whether it's a rented chair or an employed salon, we're here to help you. Okay, it's really important to say, we're here to get you the right advice into the right, areas. And we've got excellent. The good thing about SOU is we've got an army of lawyers, tax consultants, restructuring specialists, everybody. So we can put you in with whoever you need.
Awesome. Thank you very much. And thank you, everyone. Sorry I've overrun a little bit. Probably we could go on forever yabbering away, but if you've got any other questions after this, as I say, you've got our details, just reach out and we'll be happy to help. But thank you all very much for joining us, and yeah, look forward to seeing you all again soon.
Absolutely.
Thank you.
Yeah. Good night, everyone.
Take care. Good night.